Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here today with Jennifer Walrath and Doug Plass. And we're talking today about drug testing. That's a big topic, right? And we recently collaborated with ICRIMP, the Idaho County's risk management program, on a webinar related to this. And it got us thinking about all the different aspects of drug testing that flow into employment law and that create some challenges for employers so they know what they need to do, when they need to do it, and how they need to do it. So today we're going to bite off just a little chunk of that. And we're going to talk high level on drug testing. And we're going to talk about things like when you can test, some law that relates to that, some considerations, some policies, thinking through what you do if someone in your workplace reports that a coworker is impaired. So we're going to talk some high level, kind of taking these drug testing issues in chunks. And today we'll just kind of scratch the surface. Now that opens the door for later podcasts because there definitely is a whole lot of content related to drug testing and how it impacts the ADA and FMLA. And then things like, what if you're an employer in North Idaho and you've got Spokane right next to you where cannabis is legal? Like, what do you do if you're in a spot where you might have employees coming from or residing in places where cannabis is legal? What do you do if you have a remote worker who appears to be impaired? I mean, there's a lot of really interesting topics that relate to drug testing. So stay tuned. Today, we're just going to tackle some of the high-level questions and give you a basic overview of this. And I will tell you that we've had some lawsuits over the years, including one that went to trial a handful of years ago, that raise some issues related to drug testing, policies, protocols, and even interplay with issues like ADA. So we've grappled with this a little bit over time, and we're going to jump in today and kind of give you some of the things that we're thinking about and at least a starting point for you as you make sure you've got the right policies and protocols in place when it comes to drug testing. So high level, I think a good starting point is to make sure everybody understands there is somewhat of a difference here, depending on what's allowed for private employers and what's allowed for public employers. And we're going to talk a little bit about why that matters, why is there a difference, and some case law that relates to that. So I guess I'll take a beat here and see if Jen and Doug have anything they want to throw in as we get started. Any thoughts on drug testing in general and how it's kind of flowed into your practice?
We're both looking at Pam like, I thought we were talking about case law. No, it's okay. I guess what I was going to say is it's one of those topics that maybe seem simple conceptually, right? I think someone's inebriated or is on drugs and I'm going to go get them tested and find out. Or I just think they are, let's send them home and we'll sort it out tomorrow. Like, I think sometimes the knee-jerk reactions to some of this stuff that seems rational can be problematic. And sometimes those things are okay. Like, sometimes it is okay to say, we have indications someone is under the influence in the workplace. Let's send them for a test and get to the bottom of it. But there also are nuances about, which test, how soon, how do we get that all done, that maybe some employers haven't fully thought through. And also sometimes the logical, easy solution may not be the right one under the law. So I think getting a handle on these things, what are the good policies and protocols, which is what we're going to kind of jump into, right? To have them in place to then use those tools to guide you through the process is going to lead to a better result for everyone is the idea, right? Good for the employer, good for the employee, good for the workplace, the workforce as a whole, is kind of the idea.
Yeah, and I think Jennifer just brought something up. Well, somebody seems like they're impaired. What does that mean? Like when I started thinking about this morning, we have some like checklists that we were looking at. And there's so many different ways that you could describe that. And there's so many different things that could be. So like, think about that beforehand. I'm like, what do you mean that they're impaired? Well, maybe it has to do with their movement. Maybe it has to do with their speech. Maybe it has to do with their appearance. Maybe it's a report you got from somebody else. Like, think about kind of all the different ways that could present itself. And, like always, documentation is key. Like, write it down and make sure that you're clear on it. So that's one thing that I was thinking about, kind of going along to this. And then, I was thinking a lot about this kind of public employer, private employer stuff. When you're in, and we'll get into this, but when you're in the private sphere, there's a lot more stuff you can do. But when you're in the public sphere, you kind of have to have a reason for it in order to do it. So, I don't know.
Though I'll throw out, even for private employers, it's good to have a reason too.
Absolutely it is. Absolutely it is.
No, I love both of those comments. And like Jennifer said, with drug impairment, alcohol impairment in the workplace, it's somewhat of an emergency situation, right? You have to know what to do and what your protocol is so you can handle it right away. Why? Because the symptoms go away over time, right? So what you can't do is ignore it and think, well, tomorrow I'll go talk to HR, figure out the protocol, and we'll come up with a plan, right? The moments pass. So these are things that have to be carefully thought through on the front end, because when it's happening, it's definitely an emergency situation. So let's dive in a little bit and talk about what makes drug testing, a big deal, and why there is a difference between what private employers do and what public employers do. And what it really comes down to is drug testing can be considered to be a search and seizure somewhat, which maybe you've never thought of it that way, but that's how it's viewed under the law. And we have a Ninth Circuit case called Lanier versus City of Woodburn that analyzes really some of the nuances to that search and seizure concept, in the context of, can an employer just say, hey, we're going to test everybody. It doesn't really matter the position. We think that there's a public interest in making sure that all of our employees are sober and not impaired in the workplace. So Lanier is a Ninth Circuit case, and it's a little dated. It's from 2008. But it is a really important case because it takes that issue on in the context of a library employee. So that case involved a library employee who got offered a job contingent on passing a drug test. And the employee said, I don't think there's a good reason for testing me. And not only am I not going to go get your drug test, but I'm going to sue you, based on Fourth Amendment violations for trying to require me to get a drug test. And so in that case, the court took on that issue and really concluded that for employers, you can't just have a blanket policy in the public arena anyway that says we're going to test everyone. Like Doug said, you have to have a special interest that passes, a minimum threshold in order to do that.
Yeah, and I thought that case is really interesting. The stuff about, having to establish that there's some reason because there's some risk associated with this position or there's some safety issues is one thing, but there's another thing in that case that says, this isn't okay because there's no evidence that there is a drug problem here. So that started me thinking, if there was a library in that case, right? Yeah, if the library had some drug problem within their staff, that didn't have anything to do with this new employee, that might have been a good reason to go ahead and do the testing, which it kind of blows your mind. It doesn't have anything to do with the person being tested, who has nothing to do with the workplace at all. But that in itself would be enough to allow for testing, possibly.
Yeah, and I remember some commentary in that case where the library said, well, we have an interest in it, and this person in this position might have contact with kids. Like, we think that there's enough of a, importance here to require testing. And the court said, no, that's just not quite enough. Like Doug said, it's not enough just to have this really generic policy reason that any employer could latch onto. It has to be more specific to the position. And so in that case, the court found the library position at issue did not meet those qualifications for testing, and that the employee who had refused to get testing was justified in doing that. So, that kind of lays the groundwork on public versus private employers. If you're listening to this and you work for a public employer, you've got this constitutional issue that you're going to need to think through, and to really make sure that testing relates to the position at issue, that you've thought through that, and that there's a legitimate reason for doing the testing.
And I will clarify for that, like pre-employment is what we're talking about for that one, that is before you've been on the job, right? Some kind of conditional offer situation is what we're really talking about in that context.
Yeah, so let's switch gears a little bit and talk about the Idaho law that relates to drug testing. And here in Idaho, we have an Idaho code provision. It's found in Title 72, and it's Idaho Employer Alcohol and Drug-Free Workplace Act. Kind of a mouthful there. And what's really interesting is before we started our podcast today, we were kind of chatting about this law, and you don't hear a lot about it among employers, and it's tucked away in the workers' compensation section of the Idaho Code. And I was saying that I think that's the case because there are some discounts that employers may be able to get in their workers' comp coverage if they can show they've got a drug and alcohol policy and protocol in place. But as you read through this statute, what quickly becomes apparent is it's pretty generic, and it's not required. It doesn't lay out requirements for employers, things they have to do in order to perform drug testing. It's written in a way that's much more generic than that. It has some recommendations, and it takes on a few issues. It basically says if you're a private employer, you can do pre-employment testing, and it has some provisions that talk about what you might want to have in a policy. But it doesn't really give Idaho employers clear guidelines on what they can and can't do. So it is a reference, maybe a starting point. And if you're at a place where you're wanting to, maybe add a drug testing policy or make sure yours complies, you could check this statute out, see if anything resonates with you in that. And again, that's Title 72, Chapter 17. What I think is interesting on this code provision is it does have some ideas for what you should have in your written drug testing policy. And that, I would say, is probably one of the most important takeaways that you should get from this podcast is if you want to have the ability to do drug testing in the workplace, you really need to make sure you've got a solid policy in place and that it takes on a handful of issues. What type of issues? Well, you need to, make sure employees have notice of what types of testing you might implement. Generally, you might list in their pre-employment, reasonable suspicion, random. Those are the types of things you would want to list in there. And then a protocol for what's going to happen if there's a positive test result, and an appeal process for employees. You'd want that, right? Some type of basic due process fairness to show that if an employee does have a positive hit, that they've got a way to see what the result is and to at least address that if they want. So those are some of the types of things I would say, you're going to want a confidentiality policy. Those are a few high level things that should go in a drug testing policy. But obviously there's going to be a lot of fact specific stuff that you as an employer are going to want to think through too, right? Like, who are you going to use to do your drug testing? How would the collection occur? What would you do if someone's impaired? How would you get them to the location? I mean, a lot of the nuances of what you're going to do if there's an issue in the workplace may well land in that policy as well.
Yeah, and I think it's really so I've had a few employers where drug testing has come up, and oftentimes they'll have these provisions where there'll be a random policy and a reasonable suspicion policy. Make sure it's really spelled out how those things work, right? Random drug testing should truly be random. I've definitely had conversations with employers that said, well, we don't necessarily have a reasonable suspicion, but we have a good hunch, and I want to go test them under the random drug testing policy. I'm like, no, you're not. You're singling them out. So, have in your reasonable suspicion policy, what are the things that would lead you to suspect that drug use is implicated here, and use that policy. And if you have a random policy, do it truly random. Every week or every 2 weeks or every month or whatever, we're going to pick out of a hat these, this number of employees, and we're going to test them. So random means random.
Yeah, that's a good point. And, again, when you have someone impaired in the workplace, that's a big deal. It's a tall allegation to, bring against someone. And so you want to make sure you got the protocol hammered out. Like, who has the authority to trigger a reasonable suspicion test? And you need to make sure everybody in the workplace is in agreement on that, right? If it's HR, then your supervisors need to know and understand what they do if they see someone, who they bring it to, what type of support they need to have for that. Those are all somewhat of a really big deal, and you need to have given that some thought on the front end.
Yeah, and a lot of them, the policies will be like, in an accident, we test everyone. I mean, that kind of makes sense on its face, but obviously there's probably going to be some situations where drug and alcohol use couldn't have anything to do with an accident. I mean, if you're struck by lightning, anything that are these external forces. So define what you mean by that, right? Like where there's, the employee was involved in some actions that cause damage to persons or property, and or something to that effect, rather than just an accident or an injury. That might be a little bit too broad.
Yeah, as you were talking, Doug, I was just thinking, a lot of these policies we're talking about can be triggered in kind of situations where there's no indication that there is a drug or alcohol at play, right? Pre-employment, random, post-accident, right? Potentially it turns up something, but really there's something else triggering those tests. It doesn't have to do with any suspicion or a hunch that something is actually happening in the workplace that is tied to being impaired or under the influence of drugs or alcohol. So I think, I agree, very important, get all those things laid out, explained, so that everyone understands, they're on notice when and how it happens, when it falls under those categories, is going to save a lot of employers time, save some headaches, right? Because it says, this thing happened, it triggers a drug test, here's our policy, see page, 30, policy 24A, right? Whatever that is. A reasonable suspicion to me is where things can get complicated, right? Because you get to Doug's hunch. right? Maybe not Doug's hunch, but the hunch he was talking about, right? Where I just think something's going on and really dialing in on what's enough to trigger that reasonable suspicion. How many people need to agree, right? Is it one person who can send them? Is it two? And I think in the cases that we've seen this come up, that often is where there can be some challenges, right? Just making sure that you as the employer, it's a difficult place to be. As Pam has said, this can raise safety concerns in the workplace or the ability of someone to do their job, especially if they are in a safety sensitive position. At the same time, as an employer, you don't want to be acting on just like a hunch or singling people out because of rumor or assumptions. So figuring out ways that work to strike that balance, right? To have a fair and effective process, but that also can be implemented very quickly when it needs to be in order to ensure that your policies are being followed, right? I mean, a lot of employers have drug and alcohol free workplace policies, right? And it's important. So how do we do that? I think is a question for a lot of employers. I'm not sure we have an easy answer, but I think having a good policy is one of them. And then like Doug was saying, figuring out, and Pam too, actually, kind of what are the factors that we're going to use to figure out if someone checks the box essentially for sending them for a reasonable suspicion test.
And we were working with a vendor who we met at a recent conference. So Current Compliance and a company called Simply Verified. And they provided us with a checklist, which is amazing. And we're happy to share that. We've got, we're big fans of checklists. And they have a reasonable suspicion cause documentation form that they've let us use. And as you look, it's pretty genius, really, to have a checklist or a document when it comes to documenting impairment or a concern of impairment in the workplace. Again, it seems like it'd be obvious. Like you see someone, oh yeah, it's bad. There's clearly something wrong. But when you look at their checklist, it gives just all these different adjectives, I guess, like things that you would see. Is that an adjective, Jennifer? Things like bloodshot eyes. I guess it would be. Those are
I'm not sure C is an adjective, but bloodshot eyes, I think maybe descriptive.
Yeah. So this checklist, I think, would be hugely helpful because it has a lot of different ways that you could describe what you're seeing, things that might not just come to mind automatically. Like, for example, speech. There's a speech category and it has things like confused. I would say that's a common one that we hear. Like I know that when we've had cases with impairment before, employees looking or acting confused, that might be a common way to describe it. But then you get to things like cotton-mouthed. I wouldn't have thought of that one. Mush-mouthed. Wouldn't have thought of that one. Thick-tongued, slurred, stuttered, mumbled, unintelligible, fair. I mean, there's just a lot of interesting ways to describe these things. Attitude, excited, insulting, profane, combative, carefree, hilarious, sleepy, talkative, cooperative, indifferent, cocky, polite. I mean, just a checklist like this, I think could be hugely beneficial. And I think it was Doug who said this when we started. One of the things about drug testing is the documentation. You need to show that whatever justification you have for triggering something like a reasonable suspicion drug test, definitely you want to have good documentation to show you had a legitimate basis for doing it that complied with your policy. So don't forget the checklists. Something you should definitely have and be aware of and have it ready to use if something comes up. So let us know if you want that. We'll make that available. I think that the checklist is gold. It's got good stuff in it. Jennifer mentioned safety-sensitive positions. So safety-sensitive positions in both the public and the private sector you have a little more leeway to do that, right? Like whether it's law enforcement, it could be construction, people driving, people handling weapons, people in life and death situations. You're going to have more leeway. And in fact, there's going to be statutes, both probably state and federal, that are maybe even going to require that in certain situations. So just know that they're, no big surprise there, that anytime you've got somebody in a really dangerous line of work, you're going to have exceptions to the general rule and probably a little more leeway to do testing. So I think that gives a pretty broad overview, a good starting place. Again, how many times have you heard us say it? Your policy. Maybe now's a good time to pull out the handbook, check out the policies, see what you got going on with drug testing. Might be a good time to update it, get the checklist in place, and have some training, right? Do your supervisors know what to do? Do you have a vendor lined up? Do you know what the vendor's testing for? And has that been updated lately? All good things to keep in mind. Just a little reminder, we have our Law for Leaders book that we released earlier this year, and it has a chapter on drug and alcohol related issues. So chapter 9 would be a good one to check out when you're thinking about drug testing and thinking about different issues that might come up when it comes to drug and alcohol related concerns in the workplace. We have a webinar coming up on November 14th. I wanted to tell you about. It's called Compliance Consideration in Times of Political Chaos. That might be something to check out. And then I'm pretty sure we're going to have a year-end update here too on December 10th. Yes. So all those things are things to look forward to. And as we head into 2026, we'll get our new training schedule out there as well. So that's it for today. We'll see you next time on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.